stared in absolute dread at a blank Word document titled something like Synopsis _final_draft2_actually final.docx with literally zero idea of where to even begin? Well, you're in the right place. This explainer is basically your ultimate survival guide. Look, every law student eventually has to tackle a project, a seminar paper, or a dissertation synopsis. You get a topic, a strict word limit, and a looming deadline, and then you're just expected to figure out the rest. Almost nobody actually sits down and teaches you how to systematically build one of these things. Until today.
So we're going to break down the exact mechanical process of writing a legal research synopsis. To do this, we're going to reverse engineer a highly successful National Law University Delhi paper on gun jumping in competition law. We'll walk through exactly how a top-tier proposal gets built right from the ground up.
To get there, we're following a strict chronological blueprint today. We'll step through 5 distinct phases to build your research toolkit, knowing what you're writing, picking and narrowing your topic, building your literature review, using only credible sources, and finally, mastering your citation style. All right, phase 1, know what you are writing. We really need to start with the absolute baseline here, which is understanding exactly what kind of document you're actually supposed to produce.
This perfectly highlights the biggest trap students fall into. We tend to throw around terms like research paper, project, and synopsis super loosely, but they are absolutely not the same thing. A synopsis is just your proposal. Its entire job is to convince your reader that a real problem actually exists, that you know the existing literature, and that you have a structured plan to investigate it. Take our NLU Delhi sample. It's about 20 pages long, and it maps out the introduction, the literature review, and the chapterization. But those chapters, they're just the plan for what the final paper will eventually cover. The research paper itself is the fully argued, executed final product. So please, do not waste your time writing a full argued paper if your professor only asked for a plan. And on the flip side, don't just hand in a proposal when the final executed project is what's due.
Moving on to phase 2, pick and narrow your topic. Believe me, this is the phase that will dictate whether your next month of research is a total breeze or absolutely miserable. You've got to use the funnel method. Step 1, start with a really broad subject. In our sample, that broad area is competition law, specifically merger control. But obviously, that's way too massive. So step 2, you narrow it down to a live problem. Basically, find a place where the law is totally unclear or where courts are actively disagreeing. Step 3, add an original angle. I mean, writing just about gun jumping in India has been done 100 times over. But if you add a comparative angle, like testing Indian law against the EU and US control tests, suddenly you have a genuine original contribution. And finally, step 4, sanity check your available material. Before you commit to this amazing original idea, you absolutely have to ensure there's enough case law and primary material out there to actually build 15 to 20 pages. If you can only track down 2 sources, your topic is way too narrow. Take a look at how the NLU Delhi's sample handles this. They don't just give a bland definition of gun jumping. They immediately establish that live problem right in their introduction. By pointing out that the statute itself lacks a concrete list of actions amounting to consummation, leaving it wide open to judicial interpretation, that single sentence proves to the reader that there is a very real gap in the law that desperately needs researching. All right, phase 3, build your literature review. Now that our topic is locked in, we can move on to actually gathering our research. And no, that does not mean blindly Googling and skimming the first 3 results that pop up. The absolute most crucial point here is understanding the difference between primary and secondary sources and the exact order you need to read them in. Primary sources are the raw law. For our competition law sample, that means going straight to actual Competition Commission of India orders like the Etihad Airways case. You have to read the actual order itself, not someone's 2-line summary on a random blog. Now, secondary sources are what other people have written about the law, which gives your work that scholarly weight. But here is the golden rule. You must always read primary sources first. Form your own original impression of the bare act or the case before you let secondary scholarly commentaries shape or even limit your own argument. If you want your literature review to flow logically, you need to follow these 3 steps. First up, collect a solid baseline of 8 to 15 sources. Second, the very second you finish reading a source, jot down a 1-sentence summary of what it actually argues. Seriously, if you wait, you're going to forget everything and have to reread it all. Third, group your notes by theme, not by source. You want to build this review like a conversation where your sources are interacting with each other rather than just a boring laundry list of source A says this, source B says that.
In a truly great synopsis, each source does a specific job, and the entire literature review naturally points straight toward that research gap your paper is going to fill. That brings us to Phase 4. Only use credible sources. We really need to talk about vetting the stuff you find, because obviously, not everything online belongs in a law school project, and citing the wrong thing will instantly tank your grade.
Here's a credibility hierarchy you'll want to memorize. Tier 1 is your always credible bucket. Lean heavily on primary texts, government reports, and recognized peer-reviewed journals. Tier 2 is credible, but you've got to use some judgment. This includes established law firm blogs. They're written by practicing lawyers, sure, but remember they're sometimes arguing a position on behalf of a specific client. So treat them as opinion rather than neutral, objective fact. And then there's Tier 3. Avoid these completely. We're talking random SEO listicles, uncited AI chatbot output, which will absolutely confidently hallucinate fake case names, and, of course, Wikipedia. Look, yes, you can secretly use Wikipedia as a starting point to wrap your head around a topic. We literally all do it, but never, ever cite it directly. Just scroll down to the footnotes and track down the primary source it's citing instead. Finally, Phase 5. Master your citation style. We have reached the finish line. It's time to tackle the mechanical reality of proper citation practices so you can really solidify all that hard-earned credibility. Before you even think about dropping a single footnote into your document, you must verify what your institution actually wants. Do they mandate OSCA, Blue Book, some incredibly specific in-house style guide? Never guess on this. Manually reformatting 50 footnotes at 3 a.m. because you just assumed the wrong style guide is sheer agony. Always check the assignment brief first.
Now, if you are tasked with using OSCA, which is super common across UK and Indian law schools, there are foundational formats you really need to follow. Pay close attention to precise distinctions, like how case years use specific brackets, or how journal titles get single quotes while the publication names don't. You definitely don't need to memorize this right this second, but mastering these meticulous, mechanical structures is the secret sauce. It's what takes your paper from a messy student draft to a highly professional, authoritative proposal. So the next time you're facing down a brand new research project, ask yourself that one crucial test question. Who wrote your source, and can you verify it against a primary text? If you apply this framework, understanding your document, funneling your topic down, building a thematic review, and rigorously vetting your sources, you'll turn that terrifying blank page into a strategic roadmap. I'll leave you with this final thought. A brilliant legal argument built on poor research is just a house of cards waiting for a judge to blow it down. Are you building a fortress, or are you just stacking cards? Get out there and conquer that blank page.
Trying to wrap your head around the legal world a little bit better? Consider this your official invitation. Subscribe to Titiksha Legal. It is a space designed specifically for you to learn, question, and explore. Welcome to a much better way to navigate your legal journey.